Welcome to the Immigration Hour, a weekly show by an immigration attorney discussing important issues of the day. I am Attorney Stella. In the fourth video, whose visa is about to expire. In that video, we talked about several options, and one of the options is that which your condition has changed and you are now married to a United States citizen. In today's video, we will discuss the stages of adjudication. When somebody is married to a United States citizen, how do they finally become a permanent resident themselves? That's what today's video is all about. I must caution when it comes to getting married to a lawful permanent resident. To do so, you want to make sure that your visa is not yet expired. But if your visa is expired, you can be married to a United States citizen. It's not a problem because this visa, you are an immediate relative. So what are the steps that you have to take in order to become a green card holder after having been married to a United States citizen? The first step is you have to prove that you are married. You have to prove that your marriage was valid and legal. To prove that this marriage is legal, you want to make sure that you submit evidence that shows that if either party was previously married, that the marriage was terminated either by divorce, annulment, or death of the other spouse. Because in America, polygamy is actually against the law. If you cannot prove that your marriages were terminated, then you will have an issue proving your case. You have to prove that the person that you're married to is a United States citizen. You do so by either a birth certificate or a passport. If you're married to a permanent resident, you have to show that they are a permanent resident, and the proof is their green card. So you have to show that as well. Now you can prove that you're a United States citizen and that you're a lawful permanent resident. So what forms are we supposed to fill out? The forms that the petitioner is the United States citizen spouse and the green card holder. The petitioner will fill out the form I-130, and in that form, they are the petitioner. They are petitioning for you, and you, who is getting the benefit is the beneficiary. So they will petition for you. They fill out the form, and then you are the one who wants the green card. You want to adjudicate your status in the United States. So in that regard, you will fill out the form I-485, which is an application for adjustment of status. When you fill out that form, you will also fill out the form I-765, which is the application for employment authorization. You want to work while your petition is pending. Then there is also a form I-130A. The form I-130A is a supplementary form that has to be filled out by the beneficiary. The government wants more information from you about your children, your parents, who asking it's a supplementary form wanting to know more about you. So that form is to be filled out by the beneficiary, giving the government a lot more information on who they are. There is also a form I-131 application for a travel document. That form is filled out by the beneficiary. If you wish to travel out of the country and return, if you wish to travel and return while your case is pending, you fill out the form I-131 application for travel document so that you can be paroled in order to give you the ability to return to the country if you do visit your home country or if you do go out of the United States. So that is the form I-131. There is also a form I-864. The form I-864 is the affidavit of support form, and that form is filled out by the petitioner. It's a contract by the petitioner, that is the U.S. citizen's spouse, with the United States government, saying that you, the beneficiary, you will not be a ward of the state. You will not start taking government subsidies, like you will not be on welfare. And they're making a contract with the government saying that they will take care of you. They will take care of you until you become a lawful permanent resident for at least 11 years, or until you become a United States citizen. So that is what that affidavit of support, when you sign it, would put your signature on it. That's what you're promising the United States government. And to do so, you yourself, you must prove that you're working and you're paying your taxes to the government. You have to show the government your taxes for the last 3 years. Then you also have to provide your pay stubs from your employer, your current employer. If you're telling the government that, look, this person that I'm petitioning for, the person is not going to be a ward of the state. So when you do that, you've proven to the government. When you show your pay stub, and by your pay stub, you're earning more than 125% of the poverty guideline, you've proven to the government that this person whom you are vouching to take care of will not be on welfare, will not be on government subsidies. Another form that should be submitted is the form I-693, the medical form, the medical examination form. That form does not have to be filled by your attorney. It has to be filled by a USCIS civil surgeon. It is not every doctor or medical doctor in the United States that can fill out the form. It is to be filled out only by USCIS civil surgeons. So what do? They will test you for TB, and they will also make sure that you do not have any communicable diseases. I will caution most immigrants, particularly those coming from Africa, who had taken the BCG vaccination for TB, is that when you are administered that skin test, in most cases, you are positive. Don't subject yourself to medication. Ask the doctor that they should send you for an x-ray, for a chest x-ray. Because with a chest x-ray, in most cases, 99.9% of the time, you will be negative. If the chest x-ray is positive, then you take the medications. If it's negative, then you just know that it's just one of those false positives. The applications has been filled, and you have also gathered evidence to show to the government that this marriage was not entered into in order to circumvent the immigration laws, that it was not an arranged marriage, that you entered into this marriage because you loved each other, not because you did not want to go back to your home country. So when you've provided those documents, what happens next is that you add to every form that you have, that you submit, to every application, to every petition that you submit with USCIS, there is a fee. There are always exceptions, but generally there is a fee, and there's also a biometric fee, that is background check fee. So you submit these forms, you submit the evidence with the fee. So when you mail it to the government, you make sure that the fee is the right amount, because if the fee is incorrect, the applications or the package will be rejected and it will be sent back to you or to your attorney, and you will have to put in the exact amount of money. When the government receives the forms and your supporting documents and also the biometric fee, the government will send you a notice of action. They will send you a letter saying that they have received the form and indicating how much money they received as to each form. So when they do that, what will happen next is that you will receive a letter, a biographic letter. The letter will be telling you that you should go in for a background check. The letter will indicate the place where you have to go, the time, and the day that you have to be there for your background check. The government wants to make sure that you are a good person, in the sense that you are not, you haven't committed crimes anywhere in the world. So, and particularly here in the United States. So the government will do a background check for you. And that letter is intended for you to go and provide evidence so that the government can use it to do that background check. So the next thing is, you have provided the information necessary for the background check. The next thing now is, you and your spouse, you wait for your interview. While you're waiting for your interview, what the government does, in most instances, they will send you your employment authorization card, so that you can work and take care of your family. When you have your work authorization, you take it to the Social Security Administration. The Social Security Administration will give you your Social Security number. That number will help you to also go to the registry and have a driver's license so that you'll be able to get a job, work and take care of yourself, take care of your spouse and your children, your family. When you receive your social security number, guard it, because that number identifies you and you only. So you misplace it and somebody takes it and commits a crime in your name, it can become a problem in the future. So that number is your number, is designed specifically for you, so you have to guard that number. So you, the beneficiary, you are now working, taking care of your family, taking care of your husband, taking care of your wife, taking care of your child, and living the American dream while you're waiting for the interview. So soon you receive a letter in the mail telling you to come in for an interview. That letter that is provided to you will have the place, the date, and the time. So you make sure that you and your spouse, you go on time. In actual fact, go earlier than the time that is stated in that letter, so that you can sit down, be relaxed while you're waiting for the officer. If you have an attorney, your attorney will be there with you. Your attorney will be there with you during your interview. There are two types of interviews that the officer may choose to conduct. The officer, at his or her discretion, may choose to see you individually or may choose to do so jointly. In either case, your lawyer will be with you. So, you are now through with the interview. What next? If there are no discrepancies in your testimony, the officer may grant your application there and then. There may be no discrepancies and there may be some issues with the background check or any suspicion. The officer may say, we will send you a decision later. I need to do further investigation. At the time that the petition is granted, if you had been married for 2 years, you will have a 10-year green card, which means you will be given a permanent resident card without any conditions. But if at the time that that petition is granted, you have been married for less than 2 years, what you'll be given is a conditional resident card for 2 years. You will be given a conditional resident card. And what that means is that the two of you have to come back. The two of you have to file before the expiration of that card. You have to file a form I-751, application to remove conditions on residence. Application to remove condition on your residency. So you will jointly file that petition. When you file that petition, you are also required to file supplementary evidence, additional evidence, to show that your marriage is a good marriage, that you guys are living as husband and wife and you are creating assets and liabilities together. Just like any other form, that form I-751 also goes with a fee to the USCIS. You always pay a fee, except that the fee is waived, except when you ask for a fee waiver, but you always pay for a fee with these forms. As to whether you will receive a letter asking that you should go for another background check, it depends. The government, USCIS, will look at the previously submitted biographics, and if they're still good, they'll send you a note that you don't need to go for another testing. At the government's discretion, they will decide as to whether you and your spouse should jointly come back for another interview, or that they should just send in your 10-year green card for you, your permanent resident card to you. I therefore recommend that if you're sending in the 751 package, send in as much supportive documents, because again, at the officer's discretion, they will determine whether you and your spouse should come in for a second interview, or that they should just send in the permanent resident card in the mail to you. I hope that this information has been helpful, that it has enlightened you enough to be able to seek further advice or further information. As you know, our objective here is to provide information and not legal advice. If you need legal advice concerning your particular circumstances, please do not hesitate to contact our law firm or to contact any other immigration attorney. Knowledge is power. Therefore, like, share, and subscribe so that we can empower each other. Thank you.